Hey everyone, it's the Brain in a Vat here again. This story tonight is a straight up takedown. The other night, a certain Doug Hutton tried to pull off a stunt on his page. You might have heard of it, No Thanks Investigates, and I'm pretty sure not too many people caught it. I did, though. And, well, the way he did it, it was just so poorly done and so transparent. You see, the object of his affection, and the reason he even attempted the fraud, was his sugar daddy, none other than Chris McDonough himself, who was patiently sitting off stage waiting for the climax so he could make his appearance and look surprised. And, it was so charming. After Doug finished his cute little story, Chrissy was all flushed and humbled by Dougie's loving gesture. What a good puppy dog. I did it for you, the legendary Chris McDonough. Are you proud of me? Did I do well? So what was this stunt, the gag, this poorly executed gambit? Well, it seems the two of them must have concocted a plan to take another shot at trying to exonerate Chris on that Michael Crowe case. They likely figured that engaging with the whole fiasco over the false accusations against Nomadic Trek leave them walking a bit on eggshells. And that's very understandable. I mean, I'd be careful too. I'd be quietly embarrassed. Hell, I'm embarrassed for them. So one or both of them must have had the great idea to try to pull the wool over everyone's eyes by rewriting legal history. And Dougie was given the task of putting on his best 7th grade reading glasses and trying to read an article and a very long legal document in front of the class. The effort was to try to persuade you that Chrissy was the real victim in the Michael Crowe case, and they hoped that big words would convince you. They counted on no one doing any homework or being able to understand the legalese. And it was not easy for Dougie. It was painful to watch, but he gave it his best. So first Doug began with a heartwarming little soft-spoken setup, and then the con was made obvious in only like the 3rd sentence. Today, we're going to take a deeper look into the Crowe case. What happened? Was it an inside job, like McDonough said it was? Did you notice that little bit there? Was it not subtle enough? And then we're going to look at the case review. I found a few things, and I find them very interesting. Let me share this with you before we go on. It's an article about Richard Tuitt, the guy who was convicted and then later acquitted of the murder of 12-year-old Stephanie Crowe. Let's face it, he's a drug addict. And he was even arrested for methamphetamine as recently as this year. And his prior record is burglary, bribery, and escaping from jail. You see, I think this was Dougie's attempt to appear unbiased and fair, almost as if he was pretending to go into this with an open mind. But this is Dougie. And it all began to go off the rails once Dougie tried to read the big words. Listening to it was like being stuck in a haunted house as a toddler, desperately trying to find the exit and afraid that you would never escape and have to experience this horror for eternity. So what was this legal document then with the big words that Dougie began to stumble through, like a dental patient slowly coming out of anesthesia with a handful of cotton balls in his cheeks? Well, it was the 2004 ruling on the civil suit brought by the families of 3 boys falsely accused of murder in the Stephanie Crowe homicide. And the opinion was from the district court judge that resided over that case. Pretty authoritative, right? That's a pretty official-looking document. I opened it today and I read through it completely, and it was thick. And the words are huge and all legally and stuff. So, Dougie, I hope you can get through it. Surely no one will understand. So if you sound confident enough and don't swallow your tongue and choke, people might buy the con. So here were the tactics in his reading. Read a complex legal document that you don't understand. Use emphatic gestures every time a sentence seemingly sounds like it might go in McDonough's favor. For example, every time the word however is read, raise your tone and change the intonation, as if you anticipate that that word always leads to a legal conclusion in McDonough's favor, even when it doesn't. Be sure to throw all the other people who were defendants with McDonough under the bus, and pretend that while they might possibly be to blame for bad policing, McDonough had nothing to do with it, and was simply a highly educated expert who had been called in at the last minute to help out. He had no vested interest. He couldn't possibly have been in on any insider cop conspiracy to acquire false confessions. Wink, wink, nod, nod. When reading the passages that admit that the interrogators lied to the boys in order to coerce them into a confession, Hutton emphasizes that that is perfectly legal, ignoring the greater point, which was that juveniles were given no choice by the interrogators but to accept the lesser of 2 horrible choices and succumb to the psychological torture they endured, which has been called out by every legitimate legal scholar worth their salt. Hutton then tries to distract by referring to illegal search and seizure and the arrest decision, that which relates to the Fourth Amendment, not relating at all to McDonough, who was seemingly just the interrogator of the 3 boys and the alleged expert of the well-known pseudoscience of so-called computer voice stress analysis, or CVSA, which is even less dependable than a polygraph. But they're both pseudoscience mumbo-jumbo. He also conveniently glosses over the part where McDonough claimed that the boys were all lying in his tests, until after they had been coerced into confession and concession, and then, conveniently, his fraudulent test said they were right. And I couldn't help but laugh at the irony of Doug Hutton, the ex-First Amendment frauditor and cop-hater, who until only recently was calling professional and polite cops all tyrants and claiming to be the protector of constitutional rights, suddenly willing to sell out in the case of the 3 boys. Because when it came to the Fifth Amendment, or protection against self-incrimination, Hutton was fine with being an apologetic for McDonough, having clearly violated their rights. And even more hilarious is that when Hutton was harassing innocent civilians in the streets and telling cops that they beat their wives and children and kicked their dogs in the name of the First Amendment, he held aloft the virtue of his inalienable right against the state. And he hated when cops got out of civil or even criminal liability by appealing to qualified immunity. Yet that is precisely what McDonough and his fellow defendants did in the case from which he was reading. And then, in a climax, it all came to fruition. His silly con concluded with McDonough and his defendant being exonerated by appealing to just that qualified immunity principle. And ta-da! The district court judge found in their favor and granted their summary judgment. And that's that. Dougie was beaming. Even though I couldn't see him as the text was on screen, I knew that he was grinning and proud, as was Daddy McDonough waiting behind the curtain. And then Dougie did it. He belted out that he just couldn't believe that anyone could be stupid enough, or enough of a, in his words, jerk-off, to think that McDonough had done anything wrong. McDonough was completely innocent and was just the only educated one in the room who knew a fancy schmancy high-tech skill. There was only one little eensy-weensy problem that evaded Hutton's tiny little mind. He was reading the wrong document. His document was from 2004, and the district court judge found in favor of the defendants in 2004. But on appeal, the Ninth Circuit Court of Appeals completely overturned the findings of the district court judge, and their authority supersedes that of the district court judge. And guess what? When the defendants appealed to the Supreme Court, the highest court in the land, their request was denied, and the Ninth Circuit Court decision was upheld. The summary judgment that had gone in McDonough's favor in 2004 had been reversed. The boys were even deemed factually innocent, which means they can never be charged. The federal court found that the Escondido police, the employer of McDonough, violated the civil rights of Michael Crowe and the two other boys after enduring hours of grueling, psychologically abusive interrogations. They even called it psychological torture. And another renowned retired judge said that she viewed the few dozen hours of taped interrogations and that they were definitely abuse, the likes of which she had never seen at the hands of a police officer. So, Dougie, I'm your huckleberry, and you're the jerk-off. As for pronouncing legal words, it's a pretty easy tip-off when you can't read or pronounce the words exculpatory or adjudication. You butchered those words, as well as about 24 other ones. It was very painful to listen to. And you were being honest on one point. You said that you'd never read that much since high school. I think then you whispered, or college. So I'll give you that. And it does not surprise me one bit that you've not read anything that long in 20 years. And it showed. And as for Chris McDonough and the claims of being highly educated and an expert on CVSA, I'll attach all the relevant documents in the description below, completely eviscerating that pseudoscience, as well as the Reed technique of interrogation, including the correct authoritative legal document you should have been reading from 2010, Dougie, and not the wrong one from 2004. Oh yeah, and after the finding in their favor, the family had had enough and agreed to a settlement north of $7 million for the torture that those children experienced at your hands. And it's not enough.